Yes?
Yes, Judge.
What are we going to do? What's our plan?
Your Honor, we're going to plead guilty on 39246. The agreement is for deferred probation.
And then this other one?
Will be dismissed, Judge.
Okay, I'll put that aside then. And we call 22-39246, the state of Texas versus Jose Gabriel Cortez. You and Mr. Cortez?
Yes, sir.
Present with Mr. Kelly, your attorney and the state's attorney. Does the defendant waive a formal reading of the indictment and the arraignment here? Can we proceed in summary?
Do please, Judge.
In summary, sir, this indictment alleges, which was handed up on, wow, it's going on 2 years now, February 23rd of 22.
That's right.
And it alleges that on or about February 10th, 2022 in Jefferson County, Texas, you committed the second-degree felony of aggravated assault. Do you understand what you're charged with?
Yes, sir.
If convicted of a second-degree felony such as this, you face no less than 2 nor more than 20 years confinement in prison, and a fine up to $10,000 can be assessed. Do you understand?
Yes, sir.
An agreement's been reached where you would be pleading guilty, placed on deferred or unadjudicated probation, which can be up to 10 years, I think. And there will be terms and conditions of probation which are normal and customary for this. Is there any loss?
I'll have to,
And if there's restitution, I've got to announce it here.
I'll let while you proceed.
Sentencing. And then the other case will be 39247 would be dismissed as part of this agreement. Is that your understanding of the plan?
Yes, sir.
If I follow this agreement, you have no right of appeal of your case. Do you understand?
Yes, sir.
How do you plead to this charge of second-degree felony of aggravated assault, guilty or not guilty?
Guilty.
Are you pleading guilty voluntarily, that is on your own free will, and because you are guilty?
Yes, sir.
Show you what's marked as State's Exhibit 1. Did you sign that document voluntarily?
Yes, sir.
Did you understand it? Discuss it with your attorney, or the contents all true and correct?
Yes, sir.
State's Exhibit 1 is tendered
No
in
objection.
just without objection. Among other things, this states that you are mentally competent to enter your guilty plea, which is freely and voluntarily made. You know what you've been charged with. The indictment's been read to you. You've read it. You were guilty of the crime charged in any lesser included offenses, and you were giving up your rights to a jury trial and the right to the appearance, confrontation, cross-examination of witnesses. You were totally satisfied with the representation provided by your attorney. All of this is true. It states, so help you God. Is that true?
Yes.
State's Exhibit 1 is made a part of the record for all purposes. Does a pre-sentence report weigh?
Yes, sir.
No known restitution.
Okay. If nothing further, then I'm going to follow this agreement and find, sir, you are pleading guilty today in a voluntary way. You are mentally competent to do so. You understand and appreciate the consequences of pleading guilty. There's sufficient evidence from State's Exhibit 1 admitted in this hearing, along with your plea of guilty, to find you guilty beyond a reasonable doubt. But I'm not going to do that. I'm going to defer in finding you guilty and place you on deferred for unadjudicated probation for 10 years. There will be terms and conditions of probation which are normal and customary for this type of offense. Make sure you follow them. If you fail to, your probation can be revoked. You could have been found guilty and sentenced up to 20 years in prison, which you don't want. And in this case, it states that a firearm was used, and that means you would have to go for, you would not be paroled until you served 1/2 of your sentence. State won't tell me anything about this. I mean, somebody got shot, right?
Yes, sir. Correct.
That normally, you pay a price with me when you're shooting people, because you can kill people that way. And
the reality is both these victims are lucky to be alive. The case we dismissed, that victim did not suffer serious bodily injury. They suffered bodily injury. The deferred that we've worked out has a lot to do with Mr. Kelly's advocacy and dealing with Mr. Laird. He's brought him a lot of information as to the background between this individual and the other individuals. There's a history there that it had the matter proceeded to trial that would have made Mr. Cortez appear more sympathetic to a jury. And I think that's a fair way to summarize it. Of course, Mr. Kelly is more intimately involved with the details, but that's my understanding.
okay, help me out here.
It is what we're asking.
Shooting into a crowd, folks,
Judge, if you
is no way to handle a disagreement or issues.
no doubt.
And we send a message. What we do is that what we do is people are going to go out, and especially during the Christmas holidays, and get in differences, shoot somebody, and say, "I hope I fall on Judge Stevens because he's going to let me defer, and I'm not going to have to pay a price of going to jail as a condition of probation." We're using a deadly weapon to shoot people. That is a price that I think is something different from where somebody may be placed on 10 years deferred for stealing merchandise from the store.
Judge, it is all that serious, but we've weighed out the circumstances, including the defendant's age and the information that I told you has been shared with us by the defense, and I am asking that you move forward and accept this deal.
I'm accepting the deal. What I'm talking about is a condition of probation where he goes to jail for up to 6 months.
I feel that that's appropriate.
We don't, Judge. The things that you've said this morning are...
Shoot into a crowd, Tom. You just addressed this. I set a standard up here.
I know.
And I don't want people going, I'm going to shoot somebody as long as I don't kill them. I'll take the blame and I'll get on 10 years deferred and I'll use the John Stevens rule. No, this isn't Tombstone in the Old West. You don't resolve your differences and issues by shooting at people. And here is, I guess we're lucky that somebody wasn't shot and killed, but you're using a firearm to shoot at somebody, and that is a killing machine. But that is not the way to handle an issue unless you were defending your life. There's not a defense used here. So you don't commit aggravated assault and shoot at somebody with a gun. In this county has enough firearm violence. We don't need to be saying, what's the worst I can get? Deferred. That's second chance. I don't have to go to jail, and I can do that. That's not, I don't want people thinking that who have similar circumstances such as this, that it's something where a price is not paid. How long was the defendant in jail?
Few days, Judge, before the law was posted. I'd like to address it, Judge.
Go ahead.
The things that you've said this morning, Judge, are things that Gabriel and I have talked about for 2 years. You mentioned that when we started, the age of this case. That's how long we've been talking about the facts of these cases. His family's here. We've had this conversation. I'm not saying the court doesn't also have its rightful place to say those things, but we've had that conversation.
Who's here promoting shooting others? Thank you. Nobody's got their hands raised.
I'm not either, Judge. I'm not.
And as long as we are going to call ourselves civilized, it's going to pay a price. You're going to jail as a condition of probation. Question is how long? You work somewhere?
Your Honor, I would ask the court that it is now abundantly clear that option is at the court's discretion.
And it's done routinely in the circumstances where crimes of violence occur where they're placed on deferred probation. Yeah, we're going to stand for for working our issues out in a peaceful, civilized way, not shooting up the town. That's not the way we're going to do it. This is civilized. And we're going to send a message when this happens. So you're going to go to jail as a condition of probation when the probation, I signed those already. Yeah, let me see I'm going to add. Who will order I can place you in jail up to 180 days. I am going, as a condition of probation, order you, based upon these circumstances, to serve 180 days in the county jail. And when can you begin that? You don't have to do it immediately.
How long would the court give us, Judge?
After first year. Beginning, right, what's the first Friday after January 1? January 5? Can you write that down in there, please? Thank you. All right. And that will be an added condition. That's a message to you and anyone who use the gunplay to resolve issues. That's what I can do, and we're going to put people in jail who use violence. It's far too often used instead of civilized behavior. Okay, go see that lady. Thank you. Mr. Kelly?
Yes, Judge.